Hello and welcome to this edition of Talk Time. I'm Paranjoy Guha Thakurta in the studio of Lok Sabha Television here in New Delhi. And in this edition of the program, we are going to look at the fifth schedule of the Constitution of India. The particular schedule of the Constitution of India, which is all about protecting the rights of tribals, of indigenous communities. I have with me here two individuals, one young, one not so young, both of whom have studied the subject in some detail. Because the way you interpret it, this particular provision or schedule in the Constitution of India has very, very significant implications in the way in which the lives of tribal communities in the country, and there are 80 million tribals in this country, how they're impacted, how they're governed, how their lives are sought to be controlled. Let me welcome the guests who are here with me in the studio and briefly introduce them. I'm very happy to have with us here Dr. Bhupinder Singh. He retired from the Indian Administrative Service, the Orissa cadre, which he joined in 1956 and retired in 1989, and has been thereafter associated with a number of official committees dealing with the tribals. The Committee on Jharkhand, 1990. You headed the chairman of the Committee on the Plain Tribes of Assam, also called the Boro Committee, which was in 1992. Member of the Committee on the extension to scheduled areas of the 73rd Amendment, the Panchayat Extension to Scheduled Areas Act. This was the Bhuria Committee of 1994. And also, between 2002 and 2004, has been with the Constitutional Commission on Scheduled Areas and Scheduled Tribes, and also been associated with other government departments, continues to be associated with them, written a number of books and papers on the subject, and as a career civil servant has been deeply involved and associated with tribals and tribal communities. Thank you so much, Dr. Bhupinder Singh, for coming here. With us here is V.K. Manish. He's a tribal rights activist. That's how he would like to be described. Currently based in Raipur, in Chhattisgarh. Has moved a public interest litigation in the Supreme Court of India. And he had earlier worked as a scriptwriter and creative director for television programs in India and in Jakarta and Kuala Lumpur. Thank you, Manish, for coming here. Dr. Singh, if you can explain in as simple a language as possible, what was the fifth schedule all about? What is Article 244(1) of the Constitution? As a layperson, I understand that the Constitution of India, which was adopted by the Constituent Assembly on the 26th of November 1949, and then it formally came into effect on the 26th of January 1950. And the fifth schedule provides for the administration and control of what are described as scheduled areas, and on the belief that people who live in these scheduled areas, these are scheduled tribes and indigenous communities, they need some sort of a special treatment, a special protection due to their disadvantaged condition. That was what the Constitution envisaged. And as you are also aware, the sixth schedule, which is Article 244(2) and 275(1), provides for administration of the tribal areas of Assam, Meghalaya, Tripura and Mizoram. If you can kindly explain in lay language, in simple language, what were the meanings and why were these schedules a part of the Constitution?
Well, to start with, we must say that this fifth schedule of the Constitution does not stand alone. It has to be seen in conjunction with whatever else has been written about scheduled tribes in the Constitution. We had, for example, Article 15(4). Article 15, as you know, relates to no discrimination against any citizen of India. Then we have another provision in the Constitution, 16(4). There should be no discrimination in matter of employment. And then we have got Article 275(1), which says that the government of India should provide full funds for the purpose of ensuring that the infrastructure in tribal areas is brought up to the level of other states in the country, and that the welfare of scheduled tribes is also well provided for in terms of finances. Then Article 241 of 244, which you mentioned just now, relates to the areas other than Assam.
The northeast.
Yes, other areas
it's
are
Assam, Meghalaya, Tripura, and Mizoram.
other areas are the areas which you mentioned just now. But the clause 1 of Article 244 relates to areas other than the ones which you mentioned just now. And for that, for these areas other than those in Assam, Mizoram, Tripura, Schedule 5 has been inserted. So Schedule 5 has to be seen in conjunction with other provisions of the Constitution, not alone. And Schedule 5 relates mainly, as you mentioned just now, to the administration of scheduled areas and the welfare of scheduled tribes. The main provisions of the 5th schedule are that the executive power of the state in which the scheduled areas are located shall extend to the scheduled areas. That means the scheduled areas are part and parcel of the state in which they are located. The other provision in the 5th schedule is that annually the governor shall send a report to the President of India as to the developments which have been taking place and the developments as well as the let us say what has been occurring in the scheduled areas.
He's supposed to send an annual report, the governor,
yes,
to the president.
To the president, yes. But the president can also call for report at any other time of the year. It is not necessary that the report should be sent only annually, though of course as a matter of routine, the reports are being sent annually. Then we come to another important part of the 5th schedule, and that relates to the Tribes Advisory Council.
Okay, 1 minute. We'll come to that. I want to talk in some detail about the Tribes Advisory Council, the TAC, the role of the government, the governor, the role of the elected government. We're going to talk about this in slightly greater detail a little later. Let me bring in Manish into our discussion. Manish, by way of a background, we'll come to your public interest litigation a little later. What was the main purpose of the founding fathers of this country, the architects of the Constitution of India, led by Dr. Ambedkar? What was the purpose on having the 5th schedule and also the 6th schedule?
Before Constitution of India came into force in 1950, although Government of India Act 1935 was abrogated a few years earlier, but most sections of it were in operation. And before our Constitution, there is a long history of protectionist measures, which certain people like to call administration by separation of tribal tracts. Earlier they were known as excluded areas and partially excluded areas. In our Constitution, these categories are tribal areas and scheduled areas.
Right. So what you are saying, these earlier descriptions were basically British, the British government, the colonial government, they had described these as excluded areas. Yes, please go on.
In fact, we need to be clear that it is not just the Britishers. Even earlier rulers and even princely rulers had certain protectionist measures. Even in princely states, there were certain protectionist measures for tribals. Now, when we attained independence, there was a lot of fear in tribals and in our national leaders. They were deeply distrustful of the tribals. Bastar was one such case. It was called a sleeping tiger because it was trying to side with Nawab of Hyderabad, and tribal areas were mostly under the influence of certain missionaries who were opposed to nationalist Congress. So, to assuage the fears of tribals that we are not making some sweeping changes and bringing you perforce into mainstream, we are retaining some of the protectionist measures which have been part of the administration for more than a century.
Okay, so what you are suggesting, Manish, is that the 5th schedule and also the 6th schedule in the Constitution of India was meant to try and bridge that trust deficit between the tribals and the union government in Delhi and the state governments in the various provincial capitals, that these provisions are not only because they are disadvantaged economically and socially, but also to bridge that trust deficit. Have I understood you correctly?
Yes, yes, very much. And it is on this point that some of us today believe that 5th and 6th schedule were given not to accord any kind of self-governance or autonomy, but essentially not to give that self-governance and autonomy.
We'll talk to that. Let's come briefly now to the point that you started talking about, the issue of the TAC, the Tribes Advisory Council. How was this council envisaged, and the role of the governor vis-a-vis the role of the elected government, the state government headed by the chief minister? If you can kindly explain this.
Now, the Tribes Advisory Council was conceived as a body which will have 20 members, 3/4 of whom should belong to the legislature of the state. They should be MLAs, and the rest 1/4 could be open. Then the second point which concerned the Tribes Advisory Council was that they should be able to discuss matters relating to the welfare and development of tribals. They should be able to discuss these, and that in the Tribes Advisory Council these matters could come and be. But one point which comes in this Tribes Advisory Council issue is that according to the present provision of the Constitution, they can discuss matters only which are referred to them by the governor.
I see.
You mentioned about the relation between governor and the Tribes Advisory Council. So this is an important issue which links the governor with the Tribes Advisory
Manish, would you like
Council.
to add to this?
Yes, we need to go back a little earlier. This point has so often been overlooked. When provincial diarchy was introduced through Government of India Act 1919, the royal instruction to provincial governors was very clear that joint political action was still not possible. If translated in simple words, that means tribals could still not trust their provincial legislature to think for their interest and
their
benefit.
welfare.
Yeah. So it was feared that even though there is reservation in legislature, provincial legislature, their voice could be smothered. It is for this reason that governor, who is not an elected representative and who was an outsider person, he did not belong to that province.
Typically, he was nominated by the government in power in Delhi.
Before independence, he was an appointee of Governor General and Secretary to India. Yeah, but even after independence, he was always an outside person. So it was believed that somebody who did not have any personal interest in those areas,
and therefore could be expected to be autonomous, independent, unbiased.
Yes.
Okay.
But just one more thing, because he would be an outsider, he might not have very clear an idea about the ethos or the values or the sensibilities of tribals. So a body with tribal sensibility, eyes and ears of tribal sensibility was envisaged, and thus TAC came in Government of India Act 1935, and this was retained in our Constitution. From 25-member body, it was made a 20-member.
All right. I'm just stopping both of you here at this point of time, and I want to examine. We'll take a break in our program at this juncture, and in the next segment, let's examine in slightly closer detail how the TAC, the Tribes Advisory Council, has worked or not worked. What has been the actual situation on the ground? And let's look at even what our Tribes Minister, Mr. Kishore Chandra Deo, he's written letters to all the chief ministers. How is it? Has it worked in the recent past? How is it working on the ground today? Has it ensured that governance, or those who are the elected representatives in the states as well as in the union, have really worked to ensure the welfare of some of the most underprivileged, marginalized sections of Indian society, namely the tribals? That's the question that I'm going to put to both of you. We'll take a break. Dr. Bhupinder Singh, I'll get back to you. B.K. Manish, I'll get back to you. We're looking at the 5th schedule of the Constitution of India. We are looking at issues pertaining to governance of tribal areas and the rights of indigenous communities. Stay with us. We'll be back with you. Welcome back to our discussion on the 5th schedule of the Constitution of India and issues pertaining to the rights of tribals and indigenous communities. With me here in the studio of Lok Sabha Television, I have Dr. Bhupinder Singh. He retired from the Indian Administrative Service in 1989, has been associated with various government committees and official committees on tribal rights. And we have activist B.K. Manish also with us. He is based in Raipur in Chhattisgarh. Dr. Bhupinder Singh, let's step back a little bit in time before we look at how the Tribes Advisory Council has actually worked or not worked. When the Constituent Assembly, the debates were going on and the Constitution was being framed before it came into force on the 26th of January 1950, what were the main considerations that prevailed on the makers of our Constitution to ensure that you had truly an autonomous kind of a Tribes Advisory Council to ensure that the state at both in New Delhi and in the capitals and the state capitals, the provincial capitals, would be more responsible or more responsive, I should say, to the aspirations, to the needs, to the requirements of the most underprivileged sections of Indian society, the indigenous communities, the tribals. Yes, please.
As you are aware, the Constituent Assembly was very much committed to the ideal of providing enough provisions in the Constitution to ensure that the tribals keep on advancing and ultimately they become a part of the Indian nation, totally Indian nation. If they were at the bottom of development, they should be uplifted to come to the same level. Now, for this purpose, as I mentioned earlier, a number of provisions are there in the Constitution, the provisions about the rights and all that. Along with that, the founding fathers also ensured that enough funds would be available for their development purposes. Now, there had to be some special dispensation for those areas in which the tribes were concentrated, and that dispensation came in the form of this 5th schedule. Now, the Constituent Assembly went into the matter, but I will not go into the earlier phases of those discussions. I'll come to the second draft of the 5th schedule, which was presented to the Constituent Assembly in September 1949. Now, there the discussion was very detailed and a number of members took part in that. Ultimately, the form of 5th schedule came as it is today, but that doesn't mean that it did not go through various verbal upheavals. There were a lot of discussion, a lot of points of view.
What were the main areas of contention?
Yes, I'll mention that. For example, one of the important members of this committee, it was subcommittee of the big committee, was Jaipal Singh. He came from Bihar and he was very vocal about tribals moving forward.
Major Jaipal Singh.
No,
Jaipal Singh
Munda.
Jaipal Singh Munda, yes.
He was on his team.
I stand corrected, yes.
So he said that, you see, in this question of
Tribes Advisory Council.
TAC.
Yes, TAC. In this TAC, Tribes Advisory Council, it is not enough to say that they should discuss matters pertaining to the welfare and advancement of scheduled tribes. It is also necessary to say that the discussion could also pertain to the administration of those areas. That was a major issue which came into this matter. And he was very eloquent about it. And he mentioned that there are so many there are different types of tribes at different stages of development. So therefore, we need to look into this matter in greater detail. And the small matter which I can also mention here, which is also very sentimental for the scheduled tribe people. He said that instead of calling them by any other name, Vanya Jati or some such name, they should be called by the name Adivasi. But that's a small point, by the way. The major issue was this, what I mentioned earlier, and he was supported in this by other members of the Constituent Assembly, particularly I think it was
Shiban Lal Saxena.
Yes, Brijeshwar Singh and
Brajeshwar Prasad was more on unitary system, but Shiban Lal Saxena and Nazir Ahmed.
Yeah, these were the members who supported him. But ultimately, when it was time to have the curtain drawn on the discussions, K. Munshi said that this administration is a matter which is really in the realm of the executive. It should not really be brought in the realm of the Tribes Advisory Council. And somehow the view prevailed.
Okay. Manish, the view that the Tribes Advisory Council couldn't be a hands-on body that would be looking into the day-to-day administration, but instead would be, as the name itself signifies, merely an advisory body, which also means that the advice that is given is not necessarily has to be accepted or acted upon by those who are in positions of power and authority. Am I correct?
See, one has to be a bit clearer on the politics behind TAC. Let us not forget that there were at least 5 to 6 Congress chief ministers sitting in Constituent Assembly of our country, and all of them brought very bitter experiences of dealing with their provincial governors. So, and when they were in Congress governments of 1937, they had bitter fights with provincial governors due to Section 91 and 92 of Government of India Act 1935, which was the precursor to our 5th schedule and 6th schedule. They made sure that no executive function, because as we know with our constitution, provincial diarchy ended. Entire executive function came to Council of Ministers. They made sure that even a modicum of protectionist measures is not left with governor. It must also be mentioned that in the second draft of Constitution of February 1948, TAC was empowered to advise on matters of administration as well. It was only on 5th of September 1949, when 5th schedule was discussed, that Dr. Ambedkar presented a new draft. And the reason he gave for presenting a new draft, a watered down draft, was that now some princely states had joined the Indian Union, and because Raj Pramukhs were at par with governors, our national leaders had serious doubts that these Raj Pramukhs, with the help of tribals who were not really keen on joining the Indian Union, might create some trouble. So,
all right.
But
Dr. Bhupinder Singh, the question I have is, to bring this discussion to its contemporary relevance, let me put it this way. What has been the actual practice on the ground? How have these Tribes Advisory Councils worked? Yes, please.
Before I come to this particular aspect of the question, I would just like to sort of emphasize what you said earlier, that the Tribes Advisory Council was merely advisory in nature. Even if they then gave some advice on administration, it was open to the executive
to accept or not reject, to implement or not implement.
So I do not know what really were, I mean, now our friend here has explained the background and all that, but I still feel that that was not a very proper thing to do. Anyway, there's a matter.
But how have the TSCs, the Tribes Advisory Councils, actually worked on the ground?
Now, to sort of put the matter in a nutshell, they have not been functioning very effectively for various reasons. Number one, see, first of all, the number of members in the Tribes Advisory Council should have been 20. Some states have really filled up the 5 seats which need not have gone to the scheduled tribes, or they could have gone to scheduled tribes outside the Legislative Council, outside the Legislative Assembly. So these seats may not have been filled up in many states. Secondly, the discussion the discussion in the Tribes Advisory Council has not been of that nature which would really benefit the tribals. It has remained more or less formal. Part of the reason could have been that the chairperson of the Tribes Advisory
It's the Chief Minister.
could be Chief Minister or the Minister. Any other minister.
Typically, he is either the Chief Minister or the Tribal Affairs Minister.
Yes.
So he is the part of the political executive.
And there also in this Tribes Advisory Council there are bureaucrats in some states. So the discussion has more or less been circumscribed by these circumstances.
All right. A quick reaction from you. We'll take one more break in our program. Yes.
TAC,
yes, the Tribes Advisory
The Tribes Advisory Council actually holds the key to 5th schedule. Because TAC as an advisory body is not available to governor, therefore he has not been able to exercise the special functions given in 5th schedule, and it was usurped on day 1 itself in 1950 and later in 1956. Major states like Madhya Pradesh, Odisha and Bihar enacted Tribes Advisory rules in which they installed Chief Minister as its chairperson, the chairperson.
You're saying the entire system got subverted right from day 1 itself.
Yes.
Because the Tribes Advisory Council, which was supposed to be neutral of the ruling administration, was actually made subservient to the ruling administration,
Yes.
the political executive.
Yes.
The other point which I made earlier also comes in here, that the Tribes Advisory Council is supposed to discuss only those issues which are referred to it by the governor.
All right.
But this does not really give them enough scope
Okay.
to discuss the issues which really concern the tribals.
All right. Let's take our discussion forward after a break. We are a little more than halfway through our discussion. I would like you to know, I'd like you to explain to those who are listening to you, viewing you, to explain what does this mean? You know, what are the implications of having the Tribes Advisory Councils being virtually defunct or ineffective? We have here the Minister himself, the Tribal Affairs Minister, Mr. Kishore Chandra Deo, repeatedly writing a number of letters to the governors, to the chief ministers, but little action on the ground. I want also you people to explain to me the significance of the July 1997 Supreme Court judgment, often called the Samta judgment. I'd like to understand that. I'd also like to understand, in the context of the Tribes Advisory Council and the role of the governor, the various views that have been expressed, including those by the Attorney General of India in 2010, as well as the Assistant Attorney General of India in 2013. I'd like you to explain some of these issues. We'll take a break and I'll get back to both of you. We're looking at the Constitution of India, the 5th schedule of the Constitution of India. We're going to look at what this means, the 5th schedule, in terms of governing and administering areas where the poorest of the poor of this country live, the most underprivileged section, the tribals, the indigenous communities. Stay with us. We'll be back with you in a short while from now. Welcome back to our discussion on tribal rights, the 5th schedule of the Constitution of India. With me here in the studio of Lok Sabha Television, I have Dr. Bhupinder Singh. He is retired from the Indian Administrative Service, expert on the subject. I have B.K. Manish. He is an activist based in Raipur, Chhattisgarh. Dr. Bhupinder Singh, the Minister for Tribal Affairs, Mr. Kishore Chandra Deo, he's written these letters to all the governors, to the chief ministers, pointing out to them that, look, you have to activate these tribes advisory councils. But it seems that many governments, many state governments have either ignored what he has written or just simply dragged their feet.
Yes. You see, the Constitution has two provisions in regard to the power of the central government to issue instructions to the states in the matter of scheduled tribes. One is Article 339(2), which says very clearly that the center has the power to say that such a scheme, such scheme should be, for the welfare of scheduled tribes, should be taken up and implemented. And such guidance can also be given for the purpose by the central government. Secondly, in the 5th schedule itself, there is a provision in para 3 which says that the power of the central government, power of the union, we say, power of the union extends to the giving of directions to the state governments in regard to the administration of scheduled areas and welfare of scheduled tribes. So these two provisions are there in the Constitution.
But what has been the actual situation on the ground?
Now, I come back to the letters which the minister has written to the state chief ministers and the governors. They have been written under these powers, the two powers you mentioned now. What the response has been, I do not know really, but what I read and what I hear is, it has been a very tepid type of response which has come.
No, the minister himself will say that. He will acknowledge it. He has acknowledged it on more than one occasion.
Right. Now there, the role of the governor comes in. The role of the governor comes in the matter of issue of instructions. To whom does the minister here issue instructions?
I see.
He issues instructions to the governor. And the governor is in the 5th schedule in para 5. In para 5 he has got vast powers. The governor has got vast powers in para 5. He can modify any act of the parliament, any act of the state legislature, and he can issue new acts also. And to the extent, I mean, the power to the governor has been given to the extent that this can be done even retrospectively. So the governor is very powerful if you read the 5th schedule.
All right.
But that is in theory.
Only in theory. In actual practice, it has not
As you
happened.
mentioned, there has been no response really from the...
Okay. So the point is, Manish, in theory, as per the written letters of the 5th schedule, the governor has those powers. What do you do if the governor chooses not to exercise these powers? Which once again brings me to the role of the governor in this case. And let me draw your attention to something that you already know. In April 2010, the Attorney General of India, Ghulam Mohanwati, he gave an opinion on the discretionary powers of the governor and to constitute and give powers to the Tribes Advisory Council, which is, as you know, typically headed by the Chief Minister. Now, what we found in February 2013, the Assistant Attorney General, again giving a written opinion, Fawzia Mirza, giving a written opinion, saying that the governor's powers are being exercised as the constitutional head of state who acts with the aid and under the advice of the elected government, the Council of Ministers, headed by the Chief Minister, and not as per his own discretion. Now, please explain what is really the position.
This opinion of Assistant Solicitor General was given in my very own case, and I tried to explain this to Honorable High Court of Chhattisgarh. Because we have a certain way that courts obtain the opinion of Union of India, therefore the opinion of Attorney General was not taken into consideration, while the opinion tendered by Assistant Solicitor General through proper channel is on record, and therefore
Assistant Attorney General, yes.
And therefore, on the basis of Assistant Attorney General's affidavit, the Honorable High Court of Chhattisgarh has ruled that Governor does not have discretionary power in the case of framing rules for TAC under para 4.3 of the 5th schedule. But a little more than that, as you raised a while back, the issue of our Union Minister for Tribal Affairs, Mr. Chandradev, writing various letters. Mr. Kishore Chandradev is a very honest man, probably the only man who has ever expressed healthy self-doubt. Speaking in Center for Policy Research seminar on 19th of November 2012, he said that I have been writing these letters, but even I wonder whether governors have these powers, and if they don't have these powers, why are these words there? Which is where I would like to point out something. The opinion of Attorney General is not the gospel truth. Mr. Mahanvati is the first Attorney General of India who has said this. Before him, every single Attorney General has opined that governors do not have any discretionary power, and especially 4 Attorney Generals, namely Mr. Setalwar, Mr. C.K. Daftari, Mr. Nirende, and Mr. Soli Sorabji have said so in writing in Supreme Court. So, we have to understand that the very wording of 5th schedule is so erratic and irrational. 5th schedule, we tended to take that it is such a straight cut mechanism for protection of tribals. Now that we are looking back at Constituent Assembly debates and the whole mechanism of governors, we see that practically there is no democratic basis for governor to exercise the powers that have been given to him.
Dr. Bhupinder Singh,
I fully agree with him before we
yes,
proceed further.
Right. Now, I want you to add to what he has said.
Yes.
What has to be done under this circumstance, and what does this mean in terms of administering the said schedule areas and ensuring that the rights of the tribal communities are adequately safeguarded, and not just their rights being safeguarded, that the development process or the process of economic development does not bypass them altogether. We are aware of the kind of left-wing extremism that we've seen in certain parts of the country. I want you to try and explain what this means with the reality on the ground.
In the first instance, 5th schedule is a lame duck provision, number 1. Now, how to retrieve it from that position is a very difficult issue. First of all, if you want the governors to be powerful, if you want them to sort of carry on the duty which you have given to them, they must be fully empowered. In what sense? They should be fully empowered. I mean, for the present, at present, which as they are constituted, there's hardly any assistance to the governor to take up any issue of the 5th schedule. Let me take one issue only. As I mentioned to you earlier, the 5th schedule, the governor, the 5th schedule is the power to undo a legislation of the parliament.
Even with retrospective effect.
And also do certain legislation. Create
notifications and regulations.
Promulgate certain regulations. A lot of power is there. Does he have a single legal assistant? The state government is a full-fledged legal department. This gentleman sitting in Raj Bhavan, what does he have? I was secretary to the governor of Odisha. I know it was a, excuse my using this phrase, it was a question of man and a dog. Nothing more than that. The governor was there, I was there, 2-3 assistants, not general assistants were there, no legal knowledge, and ADC was there. With this type of assistance, this type of administrative machinery to assist him, is it possible to take up the horrendous task of this 5th schedule?
All right.
Is it such a small
All right.
task?
Okay. Yeah.
No, you asked, for the
yeah,
questions you asked me, what to do about it, how we can make it constructive. That is the question which you asked. Now, as I mentioned earlier, it's a sort of very rickety type of structure, and it's very difficult to repair or put it back in its original shape, a rickety structure. But nevertheless, few small things can be done. First of all, you mentioned very well, very appropriately earlier, the chief minister is in the chair of the TSC. That should really be changed. In my view, the governor should come into the chair, right. And whoever else is there, let the chief minister also be there. Let there be totally free discussions in the
total transparency in the way
transparent and free discussions. Let the TSC members, the scheduled tribes, who ordinarily do not open their mouths, let them be encouraged to say things which are germane to the scheduled tribes.
Okay, right.
Let them come.
A quick reaction. We have to take a third break, a final break. Yes, please.
we have all realized that 5th schedule and even 6th schedule for that matter has not really worked. The way to look beyond them, one effort was PISA. Probably the time has come with the 17 years of experience.
You're talking about the Panchayat Extension to Scheduled Areas Act, yes,
Yeah.
which was passed by Parliament, correct, in 1994?
1996.
1996, I stand corrected, sorry.
Yeah.
Yeah.
But the PISA was actually a desperate attempt to look beyond 5th schedule and look for newer solutions. Now that 17 years have passed and we have some bitter experiences, probably the time has come to look for better and newer models of tribal economy.
Let's discuss this. Let's discuss precisely this point that you've made. In the fourth and the final segment of our discussion, I'll come back to you, Manish. I'll come back to you, Dr. Bhupinder Singh. We take a break and I'll get back to you. We are looking at the provisions of the Constitution of India. We were looking at what needs to be done to make the administration and governance responsive to the aspirations and the requirements of indigenous communities, the tribals, the most underprivileged sections of Indian society. We'll be back with you. Stay with us. Welcome back to the fourth and the final segment of this discussion, which looks at the fifth schedule of the Constitution of India. We are looking at tribal rights, we are looking at tribal welfare issues. With me here in the studio of Lok Sabha Television, I have Dr. Bhupinder Singh, retired from the Indian Administrative Service. I have B.K. Manish, he's an activist, a tribal rights activist. Dr. Bhupinder Singh, you know, when the Panchayat Extension to Scheduled Areas Act was enacted by Parliament in 1996, it was really felt that, you know, we needed to bring the provisions of the 73rd Amendment to the Constitution, the Panchayati Raj institutions, into these tribal areas. Essentially because the fifth schedule had not been properly implemented. Maybe you can throw some light on this, because you were a member of that committee on the subject, the Bhuria committee. Yes, please.
In fact, I drafted the report also.
You drafted the report, yes, you wrote. If you can concisely give us the view, your view.
Yes, I would not look at it this way, that because this fifth schedule had to be discarded, so we bring in the PISA and all that. I would say that PISA is supplemental. It is giving powers to the panchayats. Now, so far as PISA is concerned, first of all, see, the displacement of tribals has been a very burning issue and very painful type of issue.
Yeah, the Supreme Court also had to intervene in the Samta judgment of July 1997, you know, alienation of tribal lands to private mining companies in scheduled areas.
That was
and they declared it null and void, if you remember, in 1997. Please go on, sir.
correct, yes. Now, it is not only in regard to the mines, but also in regard to the construction of dams, construction of industries, and construction of railways. Everywhere you need land, and you find this tribal land open and all that, so it's very convenient for you to acquire the land and start doing your work. The point is,
and the whole system of land ownership, pattas, are very, very, you know, non-existent in many cases. These are community owned.
Even in Samta case thing, we need to realize that the amount of land alienation, the extent of land alienation before 97 was almost nothing when compared to what has happened after Samta judgment. We also have to realize that there are certain structural impediments. We were saying again and again, we've been hearing this term, historical injustice to tribals. What is that? I keep referring back to the closing remarks of Mr. K.M. Munshi in Constituent Assembly debates on the discussion of 5th schedule. What Dr. Singh was also referring to, he said, why was the administration function taken away from TAC? He said that Bheels in my state, Bombay back then, would not even understand one word of Moneylenders Act, and he was referring to tribal legislators, and therefore they cannot be given vast powers. Therefore we are empowering the provincial governments. Now these are the very provincial governments to safeguard from which the protectionist measures were brought in to begin with. So just one thing, this very thought, this very approach needs to be corrected, and we need to understand that even the higher judiciary has not really given it the kind of thrust that is required. Samta judgment immediately after that was tried to, subversion was attempted because it was a 3-judge bench, and constitution benches after 69 have not really taken up the violation of 5th schedule and of constitutional provisions for tribals.
Acquisition of land has been a very big issue, and in PISA itself it has been said very clearly that the Gram Sabha or the Gram Panchayat, as the case may be, will be consulted before the proceedings for acquisition of land start.
But today we are seeing in Orissa, in the POSCO case, in the Lanjigar case.
That's right. That's what I was coming to. It is being violated flagrantly. The entire situation is so explosive.
No, but the agitations that have taken place in Orissa in recent months have shown that yes, many cases the Gram Sabhas have denied or have said we will not give up our land.
Refused to agree to acquisition. Still, in POSCO case, the state government has been going on, has been progressing for at least now in Nyamgiri Hills, in Vedanta case, Nyamgiri Hills, the Gram Sabha, 8 Gram Sabhas have refused to sign anything like that, and there is a little bit of stoppage in that. So that is one provision in the PISA. Second, which is very important, is in the matter of land alienation, they have been given the power to stop land alienation and restore the land which has already been. Thirdly, again topical, in regard to mining, particularly khas karke sand mining, which is now happening now in UP. It is very such a hillu. Now there, without the agreement of the this Gram Sabha and the Panchayat, it is mandatory that you require the Gram Sabha's permission to be able to stop prospects and minor minerals.
All right. Concluding remarks from you, Manish. What is the way forward now? What do you think? I know there's you moved a public interest litigation. You're arguing your case before the Supreme Court of India. What do you think should be the way forward in as concise a manner as possible in a few minutes, please?
Probably the time has come where now that we are discussing sustainable development, we can relook at our national approach to tribals. In a draft national tribal policy is stuck in Union Cabinet for last 9 years. Probably that's one place where we can start amending things. The historical injustice to tribals is forestry, modern forestry. Probably the
but you also you've also implemented the Forest Rights Act, which has changed the situation to some extent.
Our fundamental problem with Forest Rights Act and to a certain extent even PISA is that they do not start from the very standpoint of correcting historical injustices. We would have to go back to Constituent Assembly debates, the closing remarks of K.M. Munshi. Those things, those approaches have now the opportunity of being relooked, because now with the Uttarakhand tragedy and n number of natural tragedies, we are realizing that tribals are the last living examples of sustainable development. It would be really mockery if on one hand we discuss sustainable development in UN and a number of forums, and on the other hand we try to kill the way they have been living. Probably the time has come to sort out the riddle of fifth schedule and look for...
1 minute, Dr. Singh. Is that an excessively idealistic, some would say, kind of a view that you don't want industry, you don't want roads, you don't want electricity, you don't want development?
That is not his point. That is not the viewpoint.
Preserving some sort of a pristine tribal glory. Yes, please.
What I want to say is, Manish is certainly correct in many ways, but I would also say that alongside the change of attitudes which he wants to have, which may come about in course of time, we may continue to progress with the FRI, with PISA and other measures which are there. Which we need not discard those measures. They are important, but the other side is also important. Both these have to go on parallel.
Well, so thank you so much, Dr. Bhupinder Singh,
Thank you.
for coming here to the studio of Lok Sabha Television, giving us your views. A lot more needs to be done, a lot more needs to be discussed, and we surely did not have enough time to discuss all aspects of this very complex issue. But thank you so much for throwing light on this issue. Manish, thank you very much for coming here. And time alone will tell, whether our government, or whichever government, whether it be the government in Delhi or the government in Raipur or Bhopal or Ranchi or Kolkata or Bhubaneswar or wherever, Hyderabad, how responsive they become to trying to improve the lot of the poorest of the poor, the most underprivileged of Indian society. And that's at the root of left-wing extremism, that's at the root of our
For
development.
our joint sustainable future, let's hope that they do, or they begin to do.
Thank you so much, Manish, for coming here. Thank you once again.
Thank you.
And thank you very much, ladies and gentlemen, for being with us on this program, where we discuss the implications of the fifth schedule, the flaws, the anomalies of the fifth schedule of the Constitution of India, with specific reference to the rights and the welfare of indigenous communities, tribals, Adivasis, the poorest of the poor of Indian society. Thank you once again.